hard time sort of getting novelty, technical effect, and technical effect needs to sort of really do something like that, otherwise you don't have it. And then you need special instructions so that we started with our scientists to get all these done. And then when we file, we have this as the sort of to determine novelty. So with so much effort that we put in and the information scientists put in, we determine novelty and inventive merit, and finally say, okay, I have something which is patentable and I shall go and file. And then you have a difficult process. That first is the establishing patentability, drafting, filing. It can be a provisional completion, publication. You go through all this process and finally, revocation. So now with all that, there are several laws that we need to sort of, this book that I have with me, to sort of help me here. And when I say you can either file first in India or file outside of India, but you need to follow certain procedures like Section 39, get a foreign filing license. Either way, whatever you do, whether you file in India or outside, the Section 8 has to be complied with. That I'm just putting the law as such for you to recap what it really says. There is Section 1, Section 8.1, A and B. Section 8.1A is simple. You just need to give the detailed particulars of the applications that you file outside. And Section B, an undertaking that up to the time of grant, you would still be updating the patent office with this information. Whereas when it comes to Section 8.2, it is not voluntary. You don't need to voluntarily disclose it to the patent office, but at the request of the controller, it is essential, it is becoming more and more essential that you disclose all the information and the information correctly. Now, as I said, you may first file in India or first file outside of India and then come back to India through the national phase or something. Or in that case, the time starts ticking. There is this 6-month period for updating the information at the patent office, and the time starts ticking from the day you file the application in India. So if you are filing first in India, that's the first application, we still put a Form 3 saying that we are making the first application now. So that the patent, we start our sort of following the law correctly, so that like we gain the 6 months and then we take care of it. But if you're not first filing in India but coming from outside, when you first file the national phase application, it is still, it's essential that, or it's good that you remember to file the Form 3 so that you at least mention the priority country which where you have filed the application. And if you have already entered the national phase in other countries, you may have to give that information. This is by Rule 12 that we have. And you need to keep updating every 6 months, as I mentioned this already. So controller usually requests this information in the first examination report. So it's mandatory to file this in the reply to the FER or within 6 months. So it's better that we do it as quickly as possible so that we are not in trouble. Details required are like examination reports, claim amendments, oppositions, grants, rejections, withdrawals. And failure to do so are grounds in opposition as well as in revocation. When I say opposition, it's both 25(1) and 2, that's pre-grant as well as post-grant. Now, so the recommendation is, what we do is we have a reminder system. Every 5.5 months, we have some, say, 800 patent applications pending. We run a report for the 800 and go and dump 800 pieces of paper at the patent office. Done. So file prosecution details also periodically. Again, we do that as a routine. And if an FER is issued, and we are, like what happens is, the reason we do this 5.5 months is, sometimes the US has, or EP has issued an examination report, and by the, although Unilever is one organization, by the time the US attorney communicates it to us, it's 6 months. Then you need to file a petition under 137 or something. you need to make payments for it, and for 800 applications, if you are going to keep doing it, our budget goes for 6. So we are very, very careful with such an action. Now, I said 25 net, these are the grounds. And just to remind you, on the revocation, which is under 64, there is this word may be revoked on the petition, which is one of the words that has been debated, and courts have considered it differently, and we'll take a look at it. Now, what is the spirit of this section? This came from the Honorable Justice Iyengar's committee report earlier, which said it would be an advantage. So I'm reproducing the important paragraph from that. And it also says that it would be helpful for proper examination of the application. But this was done long, long time ago. But what happened is, like those days, there were no internets, there were no search engines, no nothing. And so it was helpful to have this in the spirit. And also interpret this in the right spirit that we are here. Now, this is not only for India, there are certain other countries which also have a similar kind, not exactly, I cannot point out saying they are identical provisions, but in Canada, the applicant has no duty to disclose the product but may volunteer. But if the examiner requests for it, he needs to produce it. But failure to submit sometimes can be like it's deemed abandoned, and they give a notice period and 1 year to reinstate. So that's in Canada. There is in Israel, section 18(1), Israeli law, it says that. And then in case a grant has happened during opposition or cancellation proceedings, the court can cancel the patent, give a compulsory license, reduce the term, or ask for a fine. Then US, we know that it's a sort of information which is material to patentability, restricted to that. In EP, Article 124, they ask for the search report from the priority country. And one sort of failure could be, we have to write back saying the Indian patent application has not started examination yet, so we don't have a search report. So we do communicate to the EP. Now, coming to case laws, this was one of our most really sad case that we had against Tata Chemicals. We had an EP issued, a single X document there. The examiner had taken up this document. We had justified our case against that document. We had done everything. All that we did not do was submit the IPA to the patent office. But IPA had only this single document. We thought the examiner is all, anyway, as I also told you, between Unilever and us, those days the system was not so good. We were also not so aware. We didn't produce the IPA. Today, when it is Bangladesh, Pakistan, whatever documents we have, we go and dump so much and say, here. So, and also, when you read the definition of the convention country, under section 133, it does not refer to the PCT. Although earlier, when 133 was existing, there was, India was not a part of the PCT. Even after India became a part of the PCT, the 133 was not amended. And then, so it went through. And then we did argue quite a lot on this, saying Iyengar's report, the spirit and everything, but still we couldn't succeed. Another important aspect is, under 8.1, this is where we lost out. Certain countries like Japan and Australia generate a local application number the moment a PCT application is published, as these are designated. This is not in our control. It's an automatic generation of a number. And the other party argued that we withheld the information in Japan and Australia. We did produce the INPEDOC data, which very clearly says non-entry into national phase in Japan, but that was not taken. So, we lost. Then Ajanta Pharma against Allegan, they argued based on the same thing, and then they examined, the appellate board has taken it, and the patent was revoked. Another case, very clearly the board says, since we decided to revoke this patent on the ground of non-compliance with Section 8 and obviousness, we are not dealing with other grounds such as insufficiency, etc. So Section 8 became the most important thing. But if you look at the latest, that's Phillips against Sukesh Bihar. Here, the judge has considered this word very specifically, using the word may, and so says that solely on one ground of non-compliance of Section 8 of the Act by the plaintiff, the suit patent cannot be removed. And so, I think this is the change that we are talking about, that the judges also, or the courts are also looking at it differently, and I hope this will be precedent. So learning or reminder from the board, this is what is said in the Ajanta case. He says Section 8 must be complied with, although it's tough. That's the exact language. I quote there actually. The controller must adhere to the law and should insist compliance. IPO must have a consistent stand with regard to Section 8. Controllers cannot ignore it and condone the breach. Once Section 8.1 is detailed, particulars are given, and the controller may ask for details relating to any country. So that's how the courts have closed. Thank you.
I guess I would like to just make it interactive. If you have any questions for the first speaker, we can have like 5 minutes for that.
Yeah, I have a question.
Yes.
As you said, generally when controller examiner does issue an appeal at that time, they do ask
Yes.
if at all any information related to file knowledge should be disclosed.
Yeah.
And then you said 8.2 is a voluntary,
Yeah.
not imperative on the part of applicant to submit it.
Voluntary.
What does voluntary mean?
No. If the controller asks for it, it is
If
binding.
he doesn't ask, thereafter,
If he
because
doesn't ask,
first
it's
first time you do it, patent gets granted.
Correct.
There has not been any
If the controller
rather.
doesn't ask, you are not required to submit it.
But in that case, will somebody can challenge
No.
non-compliance if at all there has been filing on that patent?
I don't think so. Because Section 8.2 here says very clearly, at the request of the controller.
So there is a lacuna in this.
Yes, very clear. No, but that's the law. So so you can't change that. If the controller didn't request, that's what happened in the Tata case with HUF. There was an error in the FER and there wasn't a real request for submitting. They said 8.2, but they asked for particulars.
But what I think is that if you are filing a foreign patent application, then there is an undertaking on Form 3 under Section 8.
That's only
And where you take undertake that I will be enclosing you or disclosing you the information
Only
about
8.1.
filing.
Only 8.1,
That's
not
8.1,
8.2.
because that
That's
somebody
8.1.
say later on if somebody opposes that, there is post grant I'm talking about. I'm challenging
Once
making
you
the
file
post
an
grant.
undertaking, madam, you are obligated. It is obligation on your
That's
part
under 8.1.
to disclose the information.
That's under 8.1, not
Yes.
8.2. Check
Yeah,
it.
8.1.
Yeah, but he's asking for 8.2.
No, my point is in totality, can anybody oppose in post grant revocation telling that some information which is definitely existing or foreign parliament has not been disclosed to the patent office?
Particularly.
Despite the fact, examiner never asked for that.
No, that can be taken
That
because
is-
he will always
Can
ask
be
for
revoked.
because that's a plus point for him.
It cannot be revoked on
It
those.
won't be revoked.
It won't be revoked.
No.
It's,
But you are
there's a
not-
lacuna in that
No, there is
patent
a-
law.
yeah.
It should be breached.
See, the foreign
But
filing particulars have to be given. That is, I filed in US, Canada, Japan, etc. This is the date of filing. This is the application number. That is under 8.1 and you have to give it. Under 8.2, you have to give the prosecution history in these countries.
Yes.
And the prosecution history is at the request of the controller.
Yeah, since if there's no request, patent gets granted, nobody can challenge during post grant
They can't,
revocation.
they can't
That's
challenge.
what I'm saying. There's a big gap.
It's not the
Awareness
ground
is-
of opposition.
it's not a
It's
gap.
not the ground.
It's not a
But he
gap,
will
it's
take
just
it
the
because
law.
he will make his case strong. That's all.
See, awareness is very important. Bring it to the notice also is very
Yes.
important. Yes, is the second point. And it's our prime responsibility to bring it to his notice. That's important. And at the same time, whether the controller has asked it or not is irrelevant.
No, responsibility is one thing, but complying with law in respect of revocation. Because responsibility is one thing, that responsibility is a necessity to comply with 8.2. Because when during FER, I had responded, I have given all the details which was prevailing at that time. PCT application 30 months window is there. FER comes in 18 months. 18 months or 12 months, I have given the information as of that time. Thereafter, an examiner never asked me.
Sir, one
Why
thing.
didn't get granted?
Sir, I think if I argue in the similar way, if you look at when we file the opposition, we'll bring it to the notice of the controller, everything. In the similar fashion, we have to bring these particular things also in his notice. What is happening in other countries also. It's our prime responsibility.
No, our responsibility is only for
Yeah.
L1.
Responsibility in
Our
terms of
responsibility of A2
It's
starts
illegal.
only after the controller requests for it.
Yeah, is a control, there's a word, controller
Repeat
request.
the language here.
Because it's a reason voluntary. The word voluntary gives a discretion to the patentee, to the applicant.
Any more questions? I have one maybe a scenario maybe we can talk about at the same time. Say, we've debated about this earlier, but maybe for the benefit of the audience. Two things. One is when you file for a foreign filing permission, the law says the application as going to be filed, right, should be submitted for the purpose of foreign filing. Yeah. And the controller himself mentioned that. Now, how do we ensure? And most of the time, I've heard even retained counsels doing this. But you just take. I know the law, but what actually happens in practice is you take an invention disclosure. You want to file it outside of India real quickly. You just take everything from the invention disclosure and file for a foreign filing permission. Now, is that the right thing to do, or should we wait till at least we have a final, the application is going to be filed, wait till that time and then apply
In
for
Form 25, if you see the Form 25, it only mentions possession of the invention for the
Is it accurate or substantially?
yeah, it's only a
It has going to be filed,
disclosure.
I guess, if I remember it right. And the application has going to be
Substantially
filed.
the same invention to the following.
In case of Intel, you see, as you know it.
A brief
when we were-
description of
representing
it.
Ireland.
It says,
Not a problem, but I'm giving you, as I have worked
it
with
says
Intel for 3
a
years.
brief description of the invention.
Yes, exactly. So what you need is,
Brief description is you just say, okay, it's a detergent composition having something.
Can be
Or,
one paragraph, one paragraph
One
or
paragraph is
something, you need to give the
sufficient.
entire specific.
But just to get support, what we do is in practice, we have the claims and the background and prior art which is known to us,
Yes.
and we submit that.
And I've had situations where the patent office came back and said, I don't see 5 pages. Right? Your disclosure is not
General
sufficient
procedure
enough.
the industry follows is that when we do the prior art, whatever is been prepared, that we submit it. At the same time, when there is any changes which has been published in the magazines, that changes will be brought to things.
And for getting permission, probably this can be adopted at the same time, right? Anyways, the patent attorney would prepare a patent application and send it to the inventors for review. And review normally takes 1 or 2 weeks with the inventor. So once you send it to the inventor at the same time, same point in time, if you can submit that application, that would be
Yeah.
very much representative of the
Of
final
what you're
application.
going to do.
Right.
So
Right.
you will save 2 weeks
I think that's what
and 2
we'll do.
things happen in
But we
that.
don't give the examples usually.
don't give the example, don't give the claims. Claims are not required in that. Just to take the permission,
Yeah.
claims are not
Yeah,
required.
just a brief
So
description.
simply brief description that this is what is my invention.
Yeah, my second question is, say, an inventor from India and an inventor from the US, they both work on the same thing. And we've again debated on this, but it's good to kind of refresh our memories.
So,
And both of these countries are first to file.
and first to disclose also.
First is, whatever, so they have their own laws. And India and the US, what do we do?
We file it, we take the permission from US because you get it in 1 day, and in India it takes 3.
Yeah, if we kick in this export compliance into it, so US, if US doesn't really care, I guess USPTO does not care if you obtained a permission from India or not.
Yeah.
They take whatever comes in. But if it's the other way, where and most of the companies have an export compliance, or they have taken license on certain certain areas where they can actually freely export technology. But there are some areas which they cannot. And when you kick the export compliance into it, what would be the recommendation?
My initial comment would be this: if it is stopped by export compliance, if it is guided by export compliance, if the technology should not come out of the US, in the first place, the invention will not be done in the soil of India at all. So if it is already done in soil of India, then we have already kind of overcome the export compliance.
Actually, the problem is not US, India. If you have China there.
Yeah,
that
if
is
you
the
add a
problem.
China or a France into it,
China
it
is
just goes mad.
the most important
Yeah.
country. So it's best to first file in China as a PCT in English.
And go for
And that is, otherwise you'll have to get the translation done, you have to do
Exactly.
all that. So China is the more difficult country.
Tell me, when you have inventors cross-border, different countries, but then you will be clear from where the invention has originated.
Yeah.
Never. That is very important. You know, from where the inventor, though your inventors may be in different locations, where was the invention actually conceptualized?
Yeah.
I mean,
But
you
actually,
are on- you are
maybe
on-
the evaluation of
you are
this
on a
will-
video conference and
Yeah.
while you are
Yes.
discussing the
Yeah.
idea
See,
evolves.
the evaluation comes in the prayer out when we go for the search. So I think that will be the answer, first answer.
Sometimes work goes on simultaneously in India and US.
Yeah.
Like in India, this happens all the time, every time. That some work is being done here on the same invention, and some work is being done there in US. And there the problem comes in, because US law says that you first file here in US and then file in abroad. India law says that as the invention has been done here, the inventor was in India, so first file it here and then file it in US. Now this depends upon the company's policy. Intel policy is that you file the case US application there in US. They always like to file it in US. So they take permission from India on behalf of Indian government. That is what is depends upon the company's policy.
Yeah, I think it depends on the CRAMS contract. Generally, this thing what is referring to, it is under contract research and manufacturing agreement between the parties in India and foreign parties. What is listed there in the agreement, that is compliant.
Party is the same. Intel is
And
here,
the
Intel
parties are
is
saying
there.
in respect of filing, whom the right belongs to, whom the IP right belongs to.
It's the same company, sir. They have R&D here in India, they have R&D there in US, Intel is one. They have subsidiary here. So the same company,
Let's keep
two
Intel out,
companies.
let's say company X or whatever.
Yeah.
I think that makes it a lot more comfortable.
I think best is to get permission from both countries and file in the EP because you get a good search report before.
I guess I asked this question to kind of, just wake us up. I guess the harmonization of laws is required because everybody knows that, some of the other law is getting violated. And, what I've heard from the expert is, if you care about a US patent, go file in the US, don't worry. Right? Because that's easy to enforce. You care about the US patent, you make sure that everything is ready, everything is in place for a US patent, or maybe, if you care about a China patent or a Japanese patent, do everything right there. But I don't think that's the right approach. I guess if we have a harmonization of laws, and if somebody, some entity can come in to say, this is what you can do in situation number 1. Situation number 2, this is what you can do, which is legally valid. I guess that's where we should go forward.